Welcome to Protecting Trade Secrets. I'm Professor Seth C. Oranburg, and I'll be your guide through this comprehensive audio course on trade secret law and strategy. Our lecture series spans 7 modules. We'll explore one of the most dynamic, consequential, and underappreciated areas of intellectual property law. You'll learn not just what trade secrets are, but how to identify them, value them, protect them, and enforce them. You'll master the legal doctrine from the Uniform Trade Secrets Act to the Defend Trade Secrets Act, and the strategic frameworks that turn doctrine into practice. And you'll leave with the tools to build comprehensive trade secret protection plans that integrate legal requirements, operational realities, and business strategy. But before we dive in, I want to orient you. This introduction addresses 4 things: why trade secrets matter, what makes this course different, how the course is structured, and what you should expect as we move through the material. Let's start with a simple question that shapes everything. Why should you care about trade secrets? Trade secrets are everywhere, but like dark matter, they're invisible. Unlike patents, which are published and searchable, or trademarks, which appear on products and advertising, trade secrets succeed precisely because they're hidden. The Coca-Cola formula, the Google search algorithm, the Netflix recommendation engine, customer lists, manufacturing processes, pricing strategies, supplier relationships, negative R&D data. These are the competitive advantages that companies build, protect, and leverage, often more valuable than any patent portfolio. And here's what makes trade secrets unique. They can last forever, as long as secrecy is maintained. Patents expire after 20 years. Copyrights eventually enter the public domain. But trade secrets, the Coca-Cola formula has been protected for over a century. KFC's recipe remains confidential, decades after Colonel Sanders' death. Trade secrets don't have expiration dates, only the requirement that you keep protecting them. This makes trade secret law essential for every business that competes on knowledge. Startups protecting algorithms before they're ready to patent. Manufacturers guarding production efficiencies. Professional services firms safeguarding client strategies. Retailers protecting logistics and supply chain innovations. Pharmaceutical companies managing clinical trial data. Technology companies controlling source code and architecture. If your competitive advantage depends on information that isn't public, you're relying on trade secrets, whether you realize it or not. But here's the challenge. Trade secret law doesn't work like other intellectual property regimes. You can't register a trade secret with the government. There's no examination process, no official certificate. Protection isn't automatic. It's earned through ongoing, systematic, visible effort to maintain secrecy. Courts call this the reasonable efforts standard, and it's the doctrinal linchpin of the entire field. What counts as reasonable? That's what this course will teach you. Not through abstract theory, but through practical frameworks, case law, and operational guidance that shows you exactly what courts expect and what clients must do. There are plenty of trade secret law courses. Most focus on doctrine. What is a trade secret? What counts as misappropriation? What remedies are available? Those are important questions, and we'll cover them thoroughly. But this course goes further. It's designed for practitioners and strategists, people who need to advise clients, build protection systems, and make enforcement decisions in the real world, where resources are limited, threats are evolving, and doctrine must translate into action. That means we integrate 3 perspectives throughout. First, legal doctrine. You'll learn the elements of a trade secret under UTSA and DTSA. You'll study misappropriation, the acts of improper acquisition, use, and disclosure. You'll understand injunctive relief, damages, criminal enforcement, and defenses. This is the doctrinal foundation, what courts require and what lawyers must prove. Second, business operations. You'll learn how to conduct trade secret audits, how to build inventories, how to classify information by value and risk, and how to design internal controls, employee agreements, training programs, access restrictions that work in practice, not just on paper. You'll explore vendor due diligence, M&A disclosure protocols, and how to share secrets without destroying them. Third, strategic frameworks. You'll learn valuation methods, cost, market, and income approaches that quantify what secrets are worth. You'll build risk matrices that map threats and prioritize mitigation. You'll apply the Calabrese-Melamed framework to decide when to seek injunctions versus damages. And you'll explore network theory, dense versus sparse networks, to understand when trade secret law adds unique value beyond contracts and norms. This integration is what makes the course practical. Doctrine tells you what the law requires. Operation shows you how to comply. Strategy shows you when and why it matters. The course is organized into 7 modules, plus this introduction and a concluding reflection. Each module builds on the previous one, from foundations to synthesis. Module 1 establishes foundations. We start with the basics. What are trade secrets? How do they differ from patents, copyrights, and trademarks? What are the 3 essential elements? Information, independent economic value from secrecy, and reasonable efforts? You'll learn the history of trade secret law, the role of UTSA and DTSA, and why this field matters strategically. Module 2 regards identification and inventory. You can't protect what you don't know exists. This module teaches you how to identify trade secrets through systematic audits, how to classify them by type, technical, business, hybrid, and how to build inventories that capture what's valuable, where it lives, and who has access. Module 3 explains valuation and risk assessment. Not all secrets are equally valuable. This module shows you how to calculate what secrets are worth using 3 valuation approaches, and how to assess the risks they face through threat modeling and risk matrices. You'll learn to allocate resources strategically, protecting crown jewels intensively, routine information proportionately. Module 4 discusses internal risk mitigation. Employees are both your greatest asset and your greatest risk. This module covers employee agreements, non-disclosure agreements, confidentiality clauses, invention assignment, non-competes, and operational controls, joiners, movers, leavers protocol, training programs, access restrictions, and how to build a culture where secrecy is a shared responsibility. Module 5 explores external risk mitigation. Secrets don't stay inside the boundaries of a business firm. They must be shared with vendors, partners, customers, and investors. This module addresses third-party non-disclosure agreements, vendor due diligence, staged disclosure in mergers and acquisitions, clean team arrangements, and how to balance collaboration with confidentiality. Module 6 covers enforcement and remedies. When protection fails, enforcement begins. This module covers proving misappropriation under UTSA and DTSA, obtaining injunctive relief, calculating damages, and making strategic enforcement choices. You'll learn about ex parte seizure, criminal prosecution under the Economic Espionage Act, and when to choose property rules versus liability rules. Module 7 puts it all together with synthesis and governance. The final module integrates everything into a comprehensive trade secret protection plan. You'll learn the 6-pillar framework, how to implement it through accountability and metrics, how to sustain it through ongoing governance, and how network theory explains when trade secret law adds unique value. This is where doctrine, operations, and strategy converge into a unified system. Each module is broken into multiple lectures, 19 substantive lectures in total, plus this introduction and a concluding reflection. That's about 6 to 7 hours of content designed to be consumed in manageable segments, but structured as a cohesive whole. Here's how to get the most out of this course. First, listen actively. These lectures aren't just information dumps. They're designed to build progressively. Each concept builds on the last. Each module sets up the next. If something doesn't make sense in Module 2, it may clarify in Module 4. If a case seems tangential in Module 3, it may reappear with new significance in Module 6. Trust the structure. Second, take notes. Audio learning works best when paired with active note-taking. Jot down key concepts, case names, frameworks, and practical takeaways. If you're a student, these notes will serve as your study guide. If you're a practitioner, they'll become your reference materials when advising clients. Third, pause and reflect. At the end of each lesson, take a moment to consolidate what you've learned. How does this module connect to the previous ones? What questions remain? What will you apply immediately? Fourth, revisit as needed. This course is designed for repeated use. The first listen gives you the arc. The second refines understanding. The third makes connections you missed. Don't expect to master everything in one pass. Finally, apply what you learn. Theory without practice is sterile. If you're a student, apply the frameworks to hypotheticals or simulations. If you're a practitioner, audit your client's protection systems. Build inventories, draft policies, assess risks. The course gives you tools, but you have to use them. Trade secret law is one of the most intellectually rich, practically consequential, and strategically important fields in all of intellectual property. It sits at the intersection of law, business, technology, and economics. It shapes how companies compete, how innovation is protected, and how knowledge flows through markets. And it's evolving rapidly. The DTSA, enacted in 2016, is still young. Courts are refining its application. AI and generative models are creating novel risks. Globalization is complicating enforcement. The field is dynamic, contested, and full of unresolved questions. This course won't answer every question, but it will give you the frameworks, the doctrine, and the strategic tools to navigate complexity with confidence. You'll leave prepared to advise clients, build protection systems, enforce rights, and adapt as the law evolves. So welcome. Thank you for investing your time. And let's get started. In the next lecture, Module 1, Lecture A, will explore the foundations. What are trade secrets? Why do they exist? And what makes them unique within the intellectual property landscape? See you there.